am Andrea Gattini. I am full professor of international law at the University in Padua, and I have an honor and privilege to be the principal, let's say, investigator of this graduate seminar.
My name is Mariko Kawano, and I'm a professor of public international law at Waseda University, Faculty of Law.
Hi everyone, my name is Kubo Mačák. I'm a professor of international law at the University of Exeter, and I am the general editor of the Cyberlo Toolkit project, which will link to some of the topics we'll be talking about later today.
Hi, my name is Gleider Hernández. I'm the professor of public international law at the KU Leuven, or the Catholic University of Leuven, where I'm the head of the Department for International European Law. I was also a member of the international group of experts that drafted the Tallinn 2.0 manual on cyber operations in international law.
Yes, we came across, me together with my friends and distinguished colleagues, that there has been no general, let's say, graduate seminar investigation on the impact of artificial intelligence on international law as such. There are much specialized studies, but not an overall view about the way artificial intelligence is challenging rules, institutions, norms of international law. And so that was the idea to gather together and to deal as many possible subjects of international law in just a week. So full immersion.
Well, this is a very exciting seminar, I think, to be involved in. AI is everywhere. It is everywhere in our students' essays. It is everywhere in a temptation to use it to correct our work. It is tempting and it is dangerous, and it can be harnessed for great practical purposes as well. And it is the complexity of technology that we seek to address. We will start on day 2, as it were. So with the keynotes will address, of course, the more conceptual issues. But on day 2, we will discuss the existing legal frameworks that exist and how flexible, resilient, and under challenge they are by these major technological innovations that have not necessarily been the subject of clear legal regulation. We will do that during the first day by starting with general international law as a legal system, and using the UN Charter as one of the important frameworks, but not the only one. We will talk about the different regimes that can be touched by the use of artificial intelligence, the use of cyber technology and cyberspace, the notion of cyberspace as a potential area of contestation that moves us beyond the physical world and into the cyber world. And we will try to introduce this as a sort of general guiding framework for the week's activities. Over the afternoon, my colleague, Professor Kuchadasvi, from the Center for Intellectual Property and Information Technology at KU Leuven, will be focusing and zooming in on the specific international human rights framework, which is a decentralized framework that has UN and international components, a great number of overlapping treaties, but also regional, EU-level, supranational, and domestic courts and institutions, all jostling for relevance and for applicability here. That will be our general introduction on day 1, the combination of the UN and international law framework, and the more specific focus on the public law of human rights protection before we move on to the more specialized regimes.
So the topics I choose is international trade, with a special focus on the WTO activities. WTO is well known for being a deep state of crisis, but a little bit surprisingly, but not so much, is very much active on the issues of artificial intelligence. Studies by the WTO has demonstrated that through artificial intelligence, there could be up to 2040, just saying 15 years, very quickly, there could be a trade growth by worldwide by 14 to 18%. So unimaginable. But of course, under some conditions, and the condition is that of the free market. And that is one of the challenges of artificial intelligence. So the free flow of data, of big data. And so on the other way around, if states have too restrictive rules on the use of artificial intelligence, do not permit cross-border data flows, then on the other way around, the general growth, the global trade growth would be reduced by 5 to 10%. So that's really the challenge of the future, or even I would say the challenge of the present. And so just to make an example, so the AI chips, the market on AI chips was in the 2023 a value of about 61 billions of dollars, and the projection is that in 10 years, and so just means in these years, will grow 10 times to 620 billions of dollars. So that's just an idea of the sheer immensity of the challenge and also the perspectives. So of course there are some problems with international in international law and international trade law with artificial intelligence, and the first one is that of trustworthiness. So we have to pay attention to aspects, of course, with privacy, with international property rights, with issues like the environmental ones, because these big data hubs are energy devouring, and so there are some problems. And so the main challenge is that one of the trustworthiness of the artificial intelligence. But the scope of the seminar day will be that to see how AI is shaping international trade law, is developing international trade law in new directions, but at the same time, it's also shaped by the existing rules of the international trade law. So that will be in the morning, and in the afternoon, the focus will shift to same subject, but seen from the perspective of the international investment law, protection, dispute settlement, ISDS. So there are some cases, but they are growing. The number of cases brought to the ICSID, to the Center of International Dispute Settlement on Investment issues, dealing with investment into new technologies and in artificial intelligence. One is which is very well known is just pending, that one of a YA against Sweden, which is still pending.
On the third day, I'm going to deal with the issues relating to state responsibility and the dispute settlement. Because during the 3 days, keynote speeches, Gleider's lecture on sources and other things, and WTO and arbitration or investment arbitration. At least as far as we talk about the issues relating to AI, it is very important to think about how to implement those rules, and also we can think about the issues relating to the violation of international legal rules. And this is the 25th year of the adoption of or the completion of the second reading by the International Law Commission of the articles on state responsibility. And at least in accordance with these draft articles, I can say that only the secondary rules are provided. But at the same time, this is a very theoretical framework. And then there are lots of arguments with regard to how to deal with injuries or causalities or those things. Therefore, it might be a nice idea to revisit the articles on state responsibility first during the morning, and then talk about the limits of the application of these articles to the issues relating to the state responsibility in relation to AI. Because many people say that AI is used in cyberspace, but what is the territoriality or what is the attribution of the activities undertaken by AI, or what is the relationship with the states? Therefore, there are lots of things to talk. And also, maybe through these discussions, I think that it will be a nice idea to revisit the current structure of the articles on state responsibility. So this is what I'm going to do during the morning. And in the afternoon, I'd like to talk about the dispute settlement mechanism. Because the reason why I'm going to deal with both morning sessions, morning and afternoon sessions, is at least the issues relating to state responsibility is closely related to the issues, the procedures for the dispute settlement. I mean, the standing before the court or how to settle peacefully the dispute, or also what is the legal issues relating to the international community or that sort of thing. Therefore, at least I would like to deal with the issues in relation to state responsibility. We have to think about how to settle the dispute or how to ensure the legality of international legal rules in the field of AI. So this is my intention, with regard to the organization of the third day.
So before I talk about the last day of the seminar, let me just say that I'm really delighted to be involved in this initiative. And there are many reasons for that. One of them is that I will be in Venice with my distinguished colleagues, and I really look forward to it. Also based on everything that we have heard so far, I think the students are in for a treat, and so are we, because we will get to listen to each other as well. But I was also really glad that when we were approached, because we titled this seminar "International Law in the Age of AI and Cyber." And I think we have gradually come to an understanding that AI and cyber are no longer niche topics. Gleider mentioned his involvement in the Tallinn Manual project. At that time, it was quite innovative, and I would even say visionary, of the members of the international group of experts that produced the Tallinn Manual to look at these questions. And now we have more and more states recognizing that how AI and cyber are being used is really important in international relations, in the way that states collaborate, in the way that they compete, and unfortunately sometimes also fight. And so states recognize that. I mentioned the Cyber Law Toolkit project. In it, we are mapping the national positions that states are drafting on how international law applies in the cyber context. As of a few weeks back, when the most recent one was published, we have monitored 37 such positions. So, states gradually recognize more and more how important this is. And thus, I think overall, on all of these topics that we have heard about, this is really an ideal topic for a graduate seminar, because students who come to discuss these things with us will have this opportunity, I would say, to combine, on the one hand, doctrinal precision, but on the other hand, with imagination and the need for critical thinking in understanding how these evolving technologies are governed by international law. So that's why I was really excited to be involved. Now, on the final day of the program, the lecture that I will give is titled AI and Armed Conflict. And so basically, I'm going to build on my research, but also on the time that I spent as a legal advisor at the International Committee of the Red Cross, for whom, of course, questions of international humanitarian law, so the law that applies in situations of armed conflict, are directly the subject of their mandate. And so I will look at how AI is being used on the battlefields nowadays in current conflicts, and also looking at possible future developments and what international law has to say about that. And so I'm going to start with the observation that we are already seeing AI affecting existing conflicts and recent armed conflicts, whether you look at Gaza, whether you look at Ukraine, whether you look at Iran. So we see that this is not merely a future possibility, but it's really a reality that we are living in. So the examples of either AI-enabled or AI-assisted technologies that we see are technologies and tools like drones, like autonomous defense systems, like machine learning tools that are used in targeting in armed conflicts, AI-supported cyber operations, where we see this interplay between AI and cyber, and also generative AI in information operations, what is sometimes called cognitive warfare. So maybe this is a good point, because this all sounds really daunting, and it's kind of all these negative or uses that have humanitarian implications. So it's a good point to flag the complementary lecture that will be given on the same day, but by Professor Anna Beduski, also from the University of Exeter. And so Anna is going to look at the more positive side of things. So how AI can be used for humanitarian purposes. In other words, for things like identifying missing persons, or for forecasting displacement in times of armed conflict, or for supporting medical care. And also, what does international law have to say about these more positive uses? And so then returning to my session, basically the legal focus will be on how international humanitarian law governs these AI technologies that I have mentioned. So I'll cover rules and principles of IHL that include distinction, proportionality, precautions, but also obligations like the obligation to conduct legal review of new technologies, of new means and methods of warfare. And so in doing that, I'll have a chance to build on a book project that I currently lead, which has the same title, International Law and Artificial Intelligence in Armed Conflict. It's a book that will come out with Oxford University Press later this year. We will see whether it will be out by the time of the seminar, but probably an early version will be done by then for sure. And so to wrap up, I think the overall message of the final day will be that while AI might change the way that wars are fought, it does not place warfare outside of the law. And so the challenge for us will be to apply the existing legal principles correctly and carefully to these new technological realities.
So the expected outcome, as you heard in these 20 minutes, we will have so many different topics, and we will get really into details and in-depth discussions. And as Kubo said, it will be a very creative approach and an interactive approach with our participants. And I'm sure that the outcome will be not just to have learned a lot and so, but to have really fruitful thought to develop the own research subjects for our participants to get into even more studies. It's just as I said at the beginning, it's the first time ever that a seminar joined together 4 different universities with a major experts, not with my exceptions, but I'm speaking of my colleagues, major experts on these subjects and the impact of artificial intelligence. And so I'm sure there will be an exciting week for not only for our participants, our young students, but for us personally. And then the outcome will be the creation of a network which will last for a long time, of the interchange of experiences, exchanging experiences and studies. So I'm looking forward to spend this week together with Mariko, with Kubo, with Gleider, with all the participants. Thank you.
I can go next. I mean, I agree with everything that Andrea has said. I would flag one component that we put in the program, which Andrea mentioned, and I think several of us, we came back to it, but I would really like to highlight it, which is the presentations and case studies that students can develop themselves. And so this will be a core component. So the seminar is not, meant as a series of lectures in which we talk at participants, they take notes and go home. But it should really be a two-way exchange. So there will be ample space for discussion, but also for students to present their own ideas, to present their own research, and in this way to get feedback from their peers, from us. And so hopefully, exactly as Andrea has just said, we will all leave Venice being enriched from these discussions. So that's something that I would flag for students who are considering whether to apply or not.
I'm expecting the exchange of views with younger generation, because definitively the students, for the people in the students' age, they have to live with AIs and further development of AI technologies. Therefore, probably even the international legal system has to adapt those new generations and new age. Therefore, at least to what extent the classical theory of state responsibility or the dispute settlement mechanism between states can respond to this new era and what we have to change in this classical system. This is a very important question for the future. Therefore, I think I appreciate the participants from four different universities, from different countries, and we can discuss freely. Therefore, at least I have no intention to continue giving lectures, and I'd like I'd like to discuss with the students as well. So this is my additional comments to the course.
This wonderful survey of ideas, I'm scrambling to think, but I do have one major point I think that I'd like to share with prospective students, and that is that the time for disciplinary silos has come to a close, and this collaborative project, this doctoral training school or graduate training school that we are organizing, is really, I think, an embrace and an acknowledgement that international lawyers, like the four of us, have inevitably to become more open to the way that other disciplines progress, the way the world around us is changing. This is everywhere. We see it with climate change and how it's being fought in international courts, and we make sense of science and the way that climatologists are dealing with things. We see with reconstructing disputes and transitional states how anthropology, history, sociology, and psychology are necessary for understanding trauma, a sense of community, grievance, how to move on. And in our summer school or our doctoral school, because it is at the end of October, sorry, slip of the tongue, but we are focusing on digital technology. We are focusing on the challenges that technology brings to the table. It's not that this is new to any legal order. International law has dealt with the invention of the caravel. It has dealt with the invention of nuclear weapons, to exploding bullets and poisonous gases. But today, we are dealing with technologies that automate, that take over human decision-making processes, that act as proxies, that allow us access that physical capabilities did not allow us to have before, with international reach, changing our notions of geography and of space. And I believe that this has immense value for all of those who are interested in the specific technological aspects. And that is part of what we're trying to bring together with all the vulnerability of being international lawyers at our base. But equally, I think that everyone who participates in this graduate school will leave with a greater appreciation of how international law fits in with other areas of learning. And that is of immense value, whether you are a researcher and an academic, or whether one day you become a practitioner or a policymaker and go in the world with the international legal toolbox and an understanding of its limits and of its potential. So in that sense, I can only speak to the other three coordinators about just what a pleasure it's been to be reflecting about this program and our genuine enthusiasm in welcoming any of you in Venice in the autumn.
Vika, may I just add just a little comment, and of course I share everything which has been said and now by Gleider, just because he had a moment of uncertainty. Is that a summer school? It's not a summer school. What's that for a school? Well, Venice is a most beautiful time in the end of October is really the perfect season to come to Venice. It's still warm, it's still quite a summer, and no tourists around. And so it's really the perfect time to come to Venice, to this late summer school, let's say.